Light-duty offers: accept, refuse, or negotiate? A practical NY workers' comp playbook. Getting injured at work is stressful, and a light-duty job offer can add confusion at an already difficult time. In New York workers' compensation cases, a light-duty offer means modified work designed to fit the medical restrictions set by your authorized treating doctor. Light duty does not mean easy work, but rather work that is adjusted to accommodate physical or psychological limitations caused by a work injury. Any valid light-duty offer must match your doctor's written restrictions exactly and must be reviewed through the New York State Workers' Compensation Board process. If a job requires lifting, standing, or other activities beyond what your doctor allows, the offer may be invalid under New York law. Employers often make light-duty offers to reduce workers' compensation costs and limit wage replacement benefits. If you refuse a valid light-duty offer without good cause, your benefits may be suspended because insurers can argue your wage loss is no longer injury-related. This is why reviewing the offer carefully with both your doctor and a workers' compensation lawyer is so important. Accepting a light-duty offer can be appropriate when the job duties, hours, and pay are clearly defined and fully comply with medical restrictions. When accepted properly, returning to work can show good faith and help keep a claim on stable footing before the Workers' Compensation Board. However, light-duty work should always be provided in writing with specific duties and a clear pay rate. Your treating physician should review the full job description and confirm in writing that the work is medically appropriate. Refusing a light-duty offer can be risky if the job is deemed suitable by the Workers' Compensation Board. A refusal may be justified if the job exceeds medical limits, is vague, informal, or pressures you to perform unsafe tasks. New York law allows benefits to be suspended if a refusal is seen as voluntary withdrawal from the labor market. Because of these risks, refusal decisions should never be made casually or without documentation. Negotiating a light-duty offer is often an overlooked option that can protect both health and benefits. You may request changes to duties, hours, or workplace accommodations if parts of the offer do not fit your medical needs. Medical support from your treating doctor provides the foundation for negotiating safer and more appropriate work conditions. When a light-duty job pays less than your pre-injury wages, you may still qualify for reduced earnings benefits. Reduced earnings benefits are calculated as 2/3 of the difference between your pre-injury average weekly wage and your post-injury earnings. Even after returning to work, you may be compensated for intermittent lost time caused by medical appointments or injury-related absences. Proper documentation and clear medical justification are essential for recovering these benefits. Conflicts often arise when an insurance company doctor says you can work but your own doctor says you cannot. In these situations, insurers may rely on their medical examiner to justify benefit suspension. Returning to light-duty work can also be used by insurers to argue that your long-term disability is less severe. New York law protects injured workers from retaliation or discrimination for filing a workers' compensation claim. Employers may not legally punish you for exercising your rights or for refusing unsafe work that violates medical restrictions. An employer is not required to create a light-duty position if none exists within the company. If no light-duty work is offered, partially disabled workers must show attachment to the labor market to continue receiving benefits. Labor market attachment requires a documented effort to find work within medical restrictions or participation in approved programs. Understanding these rules can make the difference between protecting your benefits and losing them. Working with an experienced attorney can help ensure light-duty offers are evaluated correctly under New York law. A knowledgeable lawyer can review job offers, coordinate with medical providers, and protect your claim from unnecessary risk. Choosing the right law firm can help you navigate light-duty offers with clarity and confidence. L Sanchez Law Office, PC is a law firm dedicated to protecting the rights of injured workers across New York. If you have questions about a light-duty offer, a lawyer or attorney can help you understand your options and next steps. For guidance from a trusted attorney at a dedicated law firm, contact L Sanchez Law Office, PC at 3706 82nd Street No. 304, Jackson Heights, New York, 11372, United States, or call 646-701-7990.